Professor Sachs, thank you for taking the time to share with us your ideas on tribunal-appointed independent expert. In most cases, parties appoint their own expert. However, you see some advantages in the use of independent expert appointed by the tribunal. Can you talk a bit about these advantages and the difference vis-à-vis party-appointed experts?
Yes, certainly. So thank you, Juliana. Today you often hear complaints about the system and how it works with party-appointed experts, because very often they come to completely different results as regards technical issues, as regards scientific problems, and in particular regarding quantum. So some people complain that party-appointed experts are too much defending the interest of their clients, meaning the parties that appointed them and pay for them. Sometimes the notion of hired guns is being used, which is of course not so friendly, but it mirrors a certain concern that many arbitrators have about the system. And we should not forget that there is still a certain divide between the civil law jurisdictions and the common law world, because in the common law world it is an old tradition that parties appoint their own experts in order to present their case, whereas, as you know, in civil law jurisdictions, as a rule, it is the tribunal that appoints an independent expert. Of course, the parties are free to use their party-appointed experts in addition to the tribunal-appointed expert, but party-appointed expert opinions generally are considered as partisan, as not impartial. So there is a divide, but it is true that in international arbitration there's a clear trend to use party-appointed experts, and I have not often seen cases where the tribunal indeed appointed an expert. I recall, for example, one of the softwood lumber disputes between the US and Canada and the underlying agreement on arbitration. And it is quite interesting because they refer to the LCA rules. And the LCA rules provide, among others, that the tribunal may appoint an expert. So I read with interest in the agreement that the parties, while they were agreeing on the LCA rules, specifically excluded that provision, so to make sure that the tribunal that would sit on their case would not make use of this clause, which would permit them to appoint an expert appointed by the tribunal. Now, if you look at the various national arbitration laws, this divide is not reflected, because in most laws, even in the English Arbitration Act, you see provisions that deal with the appointment of tribunals expert. You will rather not see any provision dealing with party-appointed experts. So this divide is not so much reflected in the national laws. And interestingly, countries that have recently enacted or modernized their national arbitration laws, such as Spain or Austria, and which come from a civil law culture, they now have expressly provided for the right of a party to use a party-appointed expert in the proceedings. So the legal framework is open, and it's fair to say that the legal framework permits both approaches, and there are pros and cons, and of course the general trend is to use party-appointed experts.
Thank you. The IBA rule on taking of evidence are often used in investment arbitration. Can you talk about how these rules are considered compromise solution between civil law and common law practices?
Yes, of course. The IBA rules, interestingly, put the two approaches on an equal footing. So you already in the 99 version of the IBA rules, you had two paragraphs dealing with the respective approach. So one was on party-appointed experts, and the other was on tribunal-appointed expert. the 2010 version has followed, but also refined the provisions on, in particular, on party-appointed experts. Why is this so? Well, this is so because of the widespread concern that the party-appointed experts do not always appear to be completely independent. So the IBA rules in their current version, they stress certain principles that should be applied and should govern the party-appointed expert activities, and I just have them here. So, for example, it is desired that the party-appointed expert should clearly describe the instructions from counsel or from the party that he had received, so that you understand along which lines he's working, and also a specific statement of his or her independence from the parties. So this is now required under the IBA rules. And at the end, of course, of his expert opinion, he should affirm that the statements that he makes in his report reflect his best knowledge and genuine belief in the opinions rendered. Interestingly, the 2010 version of the IBA rules now provide something which has become a widespread practice already in arbitration proceedings, namely the possibility for the tribunal to order that any party-appointed expert who will submit a report meet with his colleague from the other side and seeks to find common ground on the issues that I have addressed. Now, this is now specifically provided for in Article 5, paragraph 4. It says that they should meet in order to discuss related issues and confer on such issues. And it goes on to say that at such meeting, the party-appointed experts shall attempt to reach agreement on the issues within the scope of their expert reports, and they shall record in writing any such issues on which they reach agreement and any remaining areas of disagreement, and the reasons, therefore. So this is quite helpful. So all in all, the 2010 version of the IBA rules, I think, represent a progress in the handling of the evidence taking by experts.
Thank you. We heard about the Sachs protocol. Can you tell us about it?
And I call this expert teaming because the idea is to have more than one expert, usually two, and you select them following proposals coming from the parties. So you invite each party to come up with, let us say, 3 proposals, 3 names or companies that they would consider suitable to address the issues on which the experts have to opine. So the tribunal receives, let's say, 3 proposals from each side, then picks one out of each list, informs the parties about their selection, and invites the 2 experts chosen to set up a team and define with them the terms of reference for their mission. Obviously, to define the terms of reference, you need the parties, you must consult with them, and then the experts work under the instructions of the tribunal, but I would say with some confidence by the parties, because they have selected them. Now, this presupposes, in my view, that the experts should not have been dealing with the case in any manner before they were appointed. So they have to be fresh in the case and work from scratch. In my experience, expert teaming in this way works satisfactorily. It seems that the parties that are using this system have confidence in this model because they can be sure that at least one of the experts is an expert of their own choice. Of course, they lose some control over the proceedings because ultimately those experts, the expert team, are experts that work under the guidance of the tribunal. And communications, be it from the two experts to the parties or one expert to the parties, of course, it should not be permitted. So the expert should always communicate via the tribunal. I observed that the acceptance in this model is quite high once the parties are convinced that it could be useful in order to save costs, to focus the issues, to streamline the proceedings, and to obtain something which at the end could be a fair opinion. I don't pretend that this is a model that is suitable for every case. In particular, I doubt myself whether this is suitable when it comes to quantum. But in cases where technical issues are at stake, construction issues, regulatory issues, it can be quite helpful. And my experience is also that even though those experts have been appointed by the respective party, once they have formed this team, they work as a team. So I have rarely experienced then disputes between the experts. They tend to come up with joint solutions. Now the danger in this is that they can be compromise solutions, and that they do not reflect the correct result of the issue that they have to deal with. That is true, that may happen, but I think the advantage to have two experts in which both the parties have trust and the tribunal are quite considerable. So it's a model that I'm practicing from time to time. I've heard from many colleagues that they're using it. And so far, the echo I've received is rather positive. Thank you.